Hello students, welcome to my class. For today our topic is general defenses under the law of torts. So let's begin. For escaping liability, you can undertake certain sets of excuses. Those are referred to as general defenses. Even when a plaintiff provides for the existence of all the essential elements of a tort, it is possible in some cases for the defendant to take certain defenses which can remove his liability. These defenses are nothing but specific situations or circumstances in which a defendant is given a waiver for his tortious action. So, general defenses are specific situations or circumstances which are given to the defendant to escape liability. Though all the essential elements of tort is present in his act or omission. There are total 8 types of defenses available in tort. In today's lecture, we will learn about 8 types of general defenses that are available under the law of torts. First, voluntary non-fit injuria, that is defense of consent. Second, plaintiff is himself wrongdoer. Third, private defense. Fourth, necessity. Fifth, inevitable accident. Sixth, act of God. Seventh, mistake. Eighth, that is lastly, statutory authority. Let me explain voluntary non-fit injuria. This is a Latin term having common law origin. So, when you are learning any Latin term, it is better you break the term and understand the meaning part by part. The first one is voluntary, which means voluntarily or by willingness. And the second term is injuria, which means tortious act or breach of a private duty or infringement of a legal right. So the complete maxim voluntary non-fit injuria means willingness does not make injury. So if you are willingly undertaking a harm, there will be no infringement of a legal right. For the completion of voluntary non-fit injuria, the first and foremost thing is the plaintiff must voluntarily consent for the infliction of harm upon him. Secondly, for the defense of voluntary non-fit injuria to be available, it is necessary to show that the plaintiff's consent to the act done by the defendant was free. If it is proved that the plaintiff's consent has been obtained by fraud or under compulsion or under mistaken impression, then such consent does not serve as a good defense. And lastly, for the maxim to be applicable, it is not only important that the plaintiff knew that the risk is there, it is also important that he agreed to suffer the harm. So, mere knowledge does not imply consent of the plaintiff. Let me give you an example. Suppose my professor has a dog that bites. I know the fact, but my professor tells me to take the dog for a walk. I protested, but he forced me to do so. I take the dog for a walk and then he bites me and I am injured. Then my professor cannot take the defense as I did not want it to go. It's only because he forced me. Here, two things happened. First, I did not agree voluntarily, and second, the consent was not free. So, in this particular example, my professor is liable for the injury that has been inflicted upon me. See, here I gave a picture of two boxers fighting. It's a good example of voluntary non-fit injuria, as they both have consented for the harm that will be caused during fighting. But two things should be kept in mind. First, the boxer must play lawfully, and second, there will be no defense if there is any unlawful harm. That means if they play unlawfully, there will be no defense. Let us discuss voluntary non-fit injuria with a case law. Hall versus Brookland Auto Racing Club. In this case, the plaintiff went to see a motor race. See in this picture, the plaintiff has been highlighted in green color. The plaintiff was a spectator and there was a collision between two cars, which toppled and one was thrown among the spectators, which resulted in the injury of the plaintiff. It was held that the club, that is, the defendant, was not liable because the plaintiff, while going to watch the race, impliedly took the risk of such injury. A point is to be noted while learning voluntary non-fit injuria that rescue cases forms an exception to the application of this doctrine. If the plaintiff voluntarily encounters a risk to rescue somebody from an imminent danger created by the wrongful act of the defendant, he cannot get this defense. For example, there are three persons A, B, and me. Now, B has locked A and enraged fire in the room. Now, to save A, I enter and save A. While doing this act, I got injured. Then B cannot plead that my act was voluntarily in nature. B will be liable. For this purpose, a very good case law is Haynes versus Harwood, year 1935. The second defense is plaintiff is the wrongdoer. This concept of defense is based on the legal maxim ex turpi causa non oritur actio, which means from an immoral cause no action arises. Like if the plaintiff is himself wrong, he cannot ask for damages. For example, I have a dog in my house. Now at night, a person trespasses and my dog bites him. He cannot claim damages. But if I do something excessive, like I keep live electric wires and trespasser got electrocuted, then I will be liable for injury and he will be liable for trespassing. There will be a parallel suit. The third one is inevitable accident, which means an injury which is unexpected in nature. That is, neither you have foreseen it nor you could have avoided it. It is actually a good defense if the defendant can show that he could not avoid the injury though he took reasonable care. Now, let us discuss a case law on this ground. It's Holmes versus Mather. In this case, the defendant's horse was driven by his servant on a public highway. The horse was frightened as the dogs on the street barked and they became unmanageable. In spite of best care, they knocked down the plaintiff. It was held that the defendant was not liable as it is an inevitable accident. The defense of act of God is based on legal maxim vis major, which means superior force. For availing this offense, two provisions must be fulfilled. First, there must be working of natural forces. Secondly, the occurrence must be extraordinary, which no one anticipated and could reasonably guarded against. For example, if there is an earthquake, who can neither anticipate and nor it can be guarded. In this case, Nichols versus Marshland, the defense of act of God was successfully pleaded. Here in this case, the defendant created some artificial lakes on his land by damming some natural streams. There was an extraordinary rainfall which was heaviest in the human memory. As a result, the embankments gave away, and the rush of water washed away four bridges which belonged to the plaintiff. It was held by the court that the defendant was not liable, as such a rainfall was considered to be the act of God. Now we will learn the right of private defense. All of you are well aware of this term. Now let's see what it actually means. Law actually permits use of reasonable force to protect one's person or property. Now, when you are protecting your own body or property, it is self defense. And when you are doing the same act for some other person, that is saving other, it is termed as private defense. Private defense is a wider term than self defense. See, here I have underlined the word reasonable force. So, if I use any force which exceeds reasonable limit, that I will not get any defense for that purpose. For example, if someone tries to steal my watch, I can beat him, but I can't shoot him. If I shoot him, I will not get any protection under the law. Here I have mentioned a case for such defense, that is private defense. It's Bird versus Holbrook. In this case, the defendant had put up spring guns in the garden without giving any proper notice. A trespasser was seriously injured by its automatic discharge. It was held by the court that the plaintiff was entitled to compensation as the force was greater than that was demanded. Now, for mistake, there are two types of mistake: mistake of fact and mistake of law. Mistake of fact means that there is a factual misconception, and mistake of law is misconception of legal norms. But mistake, whether of fact or law, is generally no defense. I mean, no defense to an action for tort, but it is sometimes defendable at the discretion of the court. The principle of mistake depends upon the legal maxim ignorantia facti doth excusat, ignorantia juris non excusat, which means ignorance of fact is excusable, but ignorance of law is not excusable. This principle is followed in criminal law, law of contract, but it is not followed in tort. So, in tort, such defense is generally not available. So, let's discuss a case. It's Consolidated Company versus Curtis. In this case, an auctioneer was asked to auction certain goods which he believed to belong to the person who asked to do so. But actually, the goods were someone else's property. Thus, there was a factual mistake in this case. But the auctioneer was held liable for the tort of conversion. An act causing damage, if it is done under necessity to prevent a greater harm, it is not actionable, even though harm was caused intentionally. Now we are discussing about the defense of necessity. It is actually a complete defense. Please, students, don't get confused between necessity and private defense. In necessity, there is an infliction of harm on an innocent person, but in private defense, harm is caused upon the plaintiff who is himself the wrongdoer. Necessity is also different from inevitable accident, because in necessity the harm is intentional in nature, but in inevitable accident the harm is caused because it could not be avoided in spite of giving best efforts. Now let's see two cases in this regard. First is League versus Gladstone. It was held by the court that using force to feed a hunger striking prisoner to save his life is a necessity and thus a good defense. And the second is Cope versus Sharp. It was held in this case that entering the plaintiff's land to prevent the spread of fire is not trespass to land. It was an action of necessity. The last available defense is statutory authority. The damage resulting from an act which the legislature authorizes or directs to be done is not actionable. The immunity under statutory authority is not only for the harm which is obvious, but also for that harm which is incidental to the exercise of such authority. Suppose a rail line is constructed, so there is interference of private land, which is an obvious harm for the act of statutory authority. But when the train runs, its noise, smoke, vibrations, etc., are incidental harm that is also covered under this particular defense. So, thank you, students. This is the end of our lecture on general defenses under the law of torts. If you have any problem or you want any discussion regarding any part of this particular lecture, please write in the comment section. Thank you.